Welcome back to the Deep Dive. Today, we're doing what we do best, taking a stack of incredibly valuable source material, carefully prepared documents, focusing on adoption law, and really extracting the most important nuggets of knowledge to give you a comprehensive understanding.
Yeah, getting right into the detail.
Exactly. This particular deep dive is specifically tailored for you, our listener, especially if you're, navigating the complexities of this area of law for study or maybe even practice.
It's a tricky area for sure.
It really is. Before we truly jump in, we want to acknowledge the source of these materials. They've been made available by the University of London for educational purposes, and we sincerely appreciate them sharing these resources which form the absolute bedrock of our conversation today.
Absolutely. Great resources.
And this deep dive is brought to you by Sinorbit Academy, Sri Lanka.
Hmm.
And for any of you facing an exam on this topic soon, seriously, the very best of luck.
Hmm.
We hope by the end of this deep dive you feel significantly more ready and confident about tackling the material.
Fingers crossed this helps.
So what exactly is our mission for the next little while? We are diving deep into the world of adoption law as it stands in England and Wales, with a primary focus on the cornerstone piece of legislation, the Adoption and Children Act 2002,
Yeah.
universally known as the ACA 2002.
The ACA 2002. Yeah, that's the one you need to know inside out.
We're going to systematically unpack its fundamental purpose, the profound legal effects it creates, walk through the intricate process involved in achieving an adoption order,
Uh-huh.
examine how crucial human rights principles, like the right to family life, weave throughout it all, and ground our understanding by looking at key real-world examples illustrated by case law.
The cases really bring it to life.
They do. As our source material points out right at the very beginning, unlike some areas of law, adoption in England and Wales doesn't rely on ancient customs or common law evolution. It is entirely and purely based on statute.
Completely statutory, no common law adoption here.
And the ACA 2002 is the undisputed, absolute key piece of legislation we need to thoroughly understand.
That's right. The ACA 2002 provides the complete legal framework. Think of it as the authoritative blueprint that governs every single aspect of the adoption process and its consequences in England and Wales today. Without the ACA 2002, statutory adoption as we know it simply wouldn't exist.
Okay, let's get into it.
Yeah.
Okay, let's unpack this right from the foundational concept. At its core, legally speaking, what is adoption under this framework? Our source material is crystal clear. It is a legal process, one that Parliament has entirely created and shaped through statute.
Exactly. It's not something that developed naturally over centuries through court decisions. It was brought into being and is completely defined by legislation, primarily, as we said, the ACA 2002.
Right.
And the real power, the core legal effect you absolutely must grasp, is what happens when a court makes that final adoption order.
Here's where it gets really interesting, and this is a nugget you'll want to remember, especially if you're studying this. The effect of an adoption order is to irrevocably transfer a child from one family, their birth family, to another, their adoptive family.
Irrevocably. That word is foundational. It signifies a complete, permanent, and, legally unbreakable break with the past family and the creation of a completely new legal family unit.
A clean break, legally speaking.
It's designed to provide absolute legal security and permanence for the child within the adoptive family. That's the whole point, really.
Right, irrevocably. It sounds like a door slamming shut forever. But our source material subtly gives us a tiny hint that even irrevocable isn't quite absolute in every conceivable circumstance. It mentions an example of extreme situations where this might potentially not hold.
Oh, you mean the PKV Mr. and Mrs. K case?
Yes, that's the one. PKV Mr. and Mrs. K 2015, EWHC 2316.
Yeah, that case is a rare reminder that while the intention and the overwhelming effect of an adoption order is permanence, the law reserves a very, very minimal capacity to intervene in the most extraordinary and unforeseen circumstances.
So an exception that proves the rule, almost.
Pretty much. But it's vital to understand this is an exceedingly rare exception, not the rule. The principle remains one of permanent severance and formation of a new family. Don't get sidetracked by the exception. Focus on the rule, irrevocable.
Okay, good point. So beyond that principle of permanence, what are the concrete legal effects of the order? What else changes the moment that adoption order is made?
Okay, a core legal effect is that it immediately vests parental responsibility for the child entirely and exclusively in the adopters.
All of it.
All of it. This comes directly from S.46 of the ACA 2002. All the rights, duties, powers, and responsibilities that constitute parental responsibility transfer fully to the adoptive parents. Birth parents lose their PR.
And the impact of this is profound because of another key section, S.67 of the ACA 2002. This section creates a legal fiction.
A very powerful legal fiction. From the date the adoption order takes effect, the child is treated as if they had been born as a child of the adopters, and crucially, not as the child of anyone else.
As if born to them.
Exactly. This means that legally, the child's original parentage is completely extinguished and replaced by the new legal parentage with the adopters. It's a total legal reboot of the child's relationship status within a family.
Wow, okay. So what does that mean in practical terms for the child's life and legal standing? Our source material highlights a couple of key implications.
Well, because the child is treated as if they were born into the adoptive family, they become a member of that family for most legal purposes. This includes things like succession inheritance rights, for example.
Right.
They would generally inherit from their adoptive parents as if they were their birth child, and the legal connection to their birth family for succession purposes is severed.
And it can affect nationality, right? That's a big one.
Yes, significantly. If a child who is not a British citizen is adopted by a British citizen, they can automatically gain British citizenship from the date of the order, assuming they didn't already have it. That's covered under S.15 of the British Nationality Act 1981.
So these are direct, concrete consequences of that legal fiction established by S.67. But our source material is careful to point out it's not a complete legal transplant. There are subtle nuances and exceptions. Let's unpack those a bit.
Indeed. While the effects are far-reaching, they aren't exhaustive. For instance, the adoption order doesn't affect the descent of certain hereditary elements, things like a peerage, a dignity, or titles of honor.
Ah, the fancy stuff.
Yeah, those typically follow lines of blood descent established at creation, so adoption doesn't rewrite that specific history.
Okay, fair enough. Maybe not relevant for most people, but legally interesting. What about family relationships for other purposes, like marriage within the family? Does the legal rewrite mean the child is now prohibited from marrying other adoptive relatives?
This is where it gets slightly more complex. The child and their adoptive parents are definitely within the prohibited degrees for marriage. They cannot legally marry each other. That's clear. However, other adoptive relatives, say an adoptive uncle or aunt, are not automatically deemed to be within the prohibited degrees simply by virtue of the adoption. So, legally speaking, an adopted child could marry an adoptive cousin or uncle.
Really?
Legally, yes. Though socially it might raise eyebrows, the legal barrier based on kinship isn't created by the adoption itself in the same way it is with the parent-child relationship.
But here's the contrasting point our source makes. The child does remain within the prohibited degrees with respect to their birth family.
Correct. The legal tie in terms of parentage and parental responsibility is severed, but certain fundamental kinship relationships that would prohibit marriage, like with a birth sibling or birth parent, persist legally.
So you can't marry your birth brother even after adoption.
Exactly. This is one of those specific instances where the legal fiction of S.67 isn't applied universally for all purposes. It shows the complex balance the law tries to strike.
Fascinating. And the very purpose of adoption itself has seen a significant shift over time, hasn't it? How we view why we have adoption has really evolved.
Absolutely. Our source material clearly marks this evolution. Historically, particularly mid-20th century, adoption was often perceived and used primarily as a means to provide babies for childless couples.
Right, finding babies for couples.
It was largely driven by the needs and desires of prospective parents looking to form a family.
But that's fundamentally different from the contemporary view underpinning the ACA 2002.
Precisely. Today, the dominant perspective, the whole ethos, is that adoption is primarily about providing a family for children, particularly those who are older, have complex needs, or who are already in the care of the state and need permanent stability and a loving home.
So the focus shifted.
Explicitly shifted, from meeting the needs of adults to meeting the paramount welfare needs of vulnerable children.
That distinction is really key to understanding the spirit of the ACA 2002, isn't it? It's finding the right family for a child, not just finding a child for a family.
It is. That fundamental shift informs many of the provisions within the Act, emphasizing welfare, permanence, and stability for the child above all else.
So we've grasped the core of what adoption is and what an order does. Let's zoom out now and trace the path that led us to the ACA 2002. Adoption law hasn't stood still. It's become progressively more regulated over time.
That's right. The journey to the ACA 2002 was one of increasing legislative intervention and recognition of the profound social and legal implications of adoption. The 2002 Act wasn't created in a vacuum. It was the culmination of years of reform suggestions and reviews.
And it's helpful to understand that not all adoptions look the same. Our source material distinguishes between different types.
Yes, broadly we see public law adoptions where children are typically in the care system, and adoption is pursued often due to concerns about their welfare within their birth family, sometimes leading to adoption without parental agreement.
Those are often the really difficult cases.
They can be, yes. And then there are private adoptions, or what are often called in-family adoptions.
Okay, what falls under that?
These are situations where the state isn't necessarily initiating the process due to child protection concerns. They include contexts like a step-parent adopting a child, or grandparents or other relatives who are already caring for a child, seeking to formalize that arrangement and gain full parental responsibility through adoption.
Like the grandparents in that Reddit case.
Exactly. These private adoptions have existed for a long time, and how they've been treated by the law has varied. Our source mentions RE-T, a child refusal of adoption order. 2020 EWCA Civ 797 as a recent example involving grandparents who are seeking an adoption order, so it still happens.
The ACA 2002 famously replaced the previous main statute, the Adoption Act 1976. This major legislative overhaul followed a significant period of review and suggested reforms, approximately a decade of intense discussion.
A particularly influential piece of work in shaping these ideas was the Department of Health review conducted back in 1992. They made a number of central recommendations for how adoption law should evolve. It's worth looking at these, not just as history, but because they show the thinking that led to the ACA 2002, and importantly, highlight which ideas did and which ideas didn't quite make it into the final act.
Okay, let's break down a few key recommendations from that 1992 review. Recommendation 1 seems to reinforce the core idea of permanence we just discussed.
It did. They strongly recommended that adoption continue to be understood as an irrevocable severance. That same idea of legal links with the birth family and adjoining with a new family.
But they also suggested contact orders.
Yes. Within this, they suggested that specific contact orders should be possible, acknowledging the changing reality of adoption involving older children. They also proposed that courts should consider other orders available under the Children Act 1989, CA 1989, like child arrangements orders, then called residence orders.
Okay.
And importantly, for those caring for children who weren't parents or step-parents under a residence order, they suggested these carers should be appointed as inter vivos guardians appointed during the parent's lifetime with parental responsibility.
But with limits.
Yes, excluding the power to consent to adoption or change the child's surname without specific permission. This was about giving carers PR for daily life while preserving the birth parent's ultimate rights over adoption finality.
So, PR for care, but not for the final step of adoption, and they wanted to keep the welfare test.
Yes, they recommended that adoption agencies and courts continue to be guided by the welfare test, ensuring they considered the child's welfare both while they were a minor and looking ahead into their adulthood. They also proposed incorporating a checklist of factors similar to the welfare checklist already in S.1 of the CA 1989.
Right, the famous checklist.
And applying the no delay and no order principles from the CA 1989 to adoption cases, bringing things into line.
Recommendation 2 is where things get really interesting concerning parental consent, a topic we know is complex.
Absolutely. For children over the age of 12, they recommended that the court should not make an adoption order unless the child agreed or their agreement was dispensed with.
So, child agreement over 12, did that make it into the act?
Actually, no. That specific requirement for the child's agreement didn't make it into the final ACA 2002 in that form. Their wishes are considered, but not formal consent.
Interesting.
They specifically distinguished the parent's agreement, which they felt should be to the placement, from the child's agreement, which they felt should be to the final order. And crucially, they proposed a significant change to dispensing with parental agreement. They wanted to retain only one ground from the old law where the parent cannot be found or is incapable.
And replacing other grounds with a single, stricter test.
Yes, a single overarching test where the court would need to be satisfied that the advantages to the child of becoming part of the new adoptive family were so significantly greater than the advantages of any realistic alternative option that it would justify overriding the parent's wishes.
Significantly greater. That's a high bar.
It is. They also suggested a specific ground for dispensing with consent if a parent withdrew consent after a placement order had been made, unless significant changes had occurred since the order to justify a different outcome.
Moving to recommendation 3, they wanted to get rid of something called freeing for adoption.
Yes, freeing for adoption was a mechanism under the 1976 Act where parental rights could be terminated before a child was placed for adoption. The recommendation was to abolish this and replace it with the placement order.
Ah, the placement order. We hear a lot about that now.
And this proposed placement order would give parental responsibility to the prospective adopters once the child was placed with them. But importantly, it would not remove the birth parent's parental responsibility at that stage.
So under the proposed placement order, both the prospective adopters and the birth parents would hold PR simultaneously for a period.
Precisely. That was the idea. Give the prospective adopters necessary authority to care for the child daily while the child was placed with them, without completely severing the birth family ties until a final adoption order was made.
Recommendation 4 specifically addressed step-parents and other carers.
They suggested a new form of order specifically for step-parents, different from adoption, which could be undone, for example, upon divorce or the death of the birth parent. This order, distinct from adoption, would provide legal security for the step-parents' relationship, but with less permanence than adoption.
Did that specific step-parent order happen?
Not exactly in that form. We got special guardianship instead, which serves a similar purpose in some ways, but isn't exclusively for step-parents. They also proposed provisions for PR orders between parents and step-parents.
Okay.
For people other than parents or step-parents who had been caring for a child, they recommended they could apply for an adoption order if the PR holders agreed. If there was no agreement, they could still apply if the child had lived with them for a cumulative period of 3 years out of the previous 5.
That 3-year residency period for non-consenting relatives sounds very much like what ended up in the ACA 2002.
It does, doesn't it? It clearly influenced the final legislation.
And Recommendation 5 focused on the child's perspective.
Yes, underlining the child's fundamental right to know about their origins. They recommended that children aged 12 and older should automatically be parties to adoption proceedings, and that courts should have the discretion to add children under 12 as parties in appropriate cases to ensure their voice was heard and represented.
So those were the main ideas from the 1992 Department of Health Review. Our source also mentions the Performance Innovation Unit's adoption review in 2000. What was the driving force behind that review?
Their primary focus was, well, quite different. It was about increasing the rate of adoption for children who were in state care. At the time, the number of children in care who were adopted was quite low, around 4% apparently.
Only 4%.
Yeah, and there was a governmental push to achieve permanence for more of these children through adoption.
And they proposed strategies specifically aimed at boosting those numbers.
Yes. Their strategies included identifying children for adoption earlier in the care process, speeding up the overall process, improving the recruitment and assessment of prospective adopters, and encouraging applications from diverse groups, including single people.
I can see a potential tension arising here. On the one hand, the Children Act 1989 S.34 specifically generally promotes children being brought up within their families, including extended family.
Right, the principle of family preservation where possible.
On the other hand, a push to speed up adoption might, in some cases, potentially conflict with taking sufficient time to thoroughly explore all viable family placement options.
Absolutely. There's an inherent tension there, isn't there, between the desire for swift permanence for children in care and the principle of preserving family links where possible and safe.
So, a potential conflict.
The tone of the 2000 review was strongly in favor of streamlining and increasing adoption numbers, particularly by making it easier to dispense with parental agreement where welfare justified it, aligning with the stricter dispensing test proposed earlier and ultimately adopted in the ACA 2002.
Okay.
It's important to remember, as our source points out, that the final ACA 2002 didn't implement all of these recommendations exactly as they were first suggested, but these reviews certainly provided the impetus and many of the core ideas.
Got it. So the ACA 2002 is the significant piece of legislation that emerged from this period of reform, replacing the 1976 Act. And it's seen further amendments since, notably by the Children and Families Act 2014. That's our main focus. All right, we've looked at the history and the motivations behind the law. Now let's get practical. Who are the people and organizations actually involved in making adoptions happen?
Well, the final legal step, making the adoption order itself, is done by an authorized court. This is now consolidated within the family court.
Okay, so the family court grants the order. But all the groundwork, the preparation, the assessment, the matching that's done by adoption agencies.
Right, that's right. These agencies are the engine room of the process. Local authorities have a fundamental duty under S.3 of the ACA 2002 to provide a comprehensive adoption service or ensure that service is provided by an approved adoption society.
A duty, so they have to do it.
Yes. And this includes not just the process leading to placement, but also providing crucial adoption support services after the adoption order is made. That post-adoption support is key.
They have to publish a plan detailing what services they provide. Is that plan entirely decided locally?
While locally managed, these services and plans are heavily influenced and prescribed by national standards and targets set by the government. And to ensure quality and consistency, these local authority adoption services are subject to inspection by Ofsted.
Ofsted, like schools.
The very same. The same inspectorate responsible for schools. This provides a level of accountability and oversight from central government.
Can voluntary organizations also be adoption agencies?
Yes, absolutely. Voluntary organizations can operate as registered adoption agencies, that's under Sections 9 and 10 of the ACA 2002, provided they meet the necessary standards and are approved. They often work collaboratively with local authorities, playing a vital role in finding and assessing prospective adopters and facilitating placements. Sometimes they specialize in certain types of placements.
And these agencies utilize adoption panels. What exactly do these panels do?
Adoption panels are composed of independent members, usually a mix of social workers, medical advisors, and people with personal experience of adoption, like adopters or adopted adults.
So range of perspectives.
Exactly. Their role is advisory but highly influential. They consider proposed adoption plans for children, assess and approve prospective adopters, and review proposed matches between specific children and approved prospective adoptive families.
Advisory, but important.
Yes. The agencies are legally required to consider the recommendations made by these panels when making their final decisions, although the final decision rests with the agency decision maker, not the panel itself.
Now here's a critical point about the process that our source material highlights. And it's something you need to be particularly aware of because it carries a significant legal penalty if you get it wrong. A real warning flag here.
Yes, this is about unsupervised or informal arrangements. Any private placement of a child for adoption, other than those explicitly permitted and regulated by the Act, such as step-parent or specific in-family placements done correctly with notice to the LA, is a criminal offense.
A criminal offense. That sounds very serious. So if someone tries to bypass the official system, like a birth parent, directly giving their child to someone who isn't a relative or approved carer outside of the statutory process, both parties could face criminal charges.
Exactly. Sections 92 and 93 of the ACA 2002 make it crystal clear this is prohibited and criminal. It's designed to prevent unregulated placements that could put children at risk, as agencies provide vital safeguards and assessments. You can't just hand a child over for adoption informally.
But, and this is the interesting legal distinction our source points out, an unlawful placement, even though it's a crime, does not automatically prevent an adoption order from ultimately being made in respect of that child.
This is because the court's paramount consideration is always the child's welfare. If, despite the unlawful initial placement, the court concludes that making an adoption order with the prospective adopters is truly in the child's best interests, it can still do so.
But it's not straightforward.
No, not at all. Making such an order following an unlawful placement requires obtaining a specific dispensation from the High Court. You need the High Court's permission to basically regularize the situation.
So the adults involved face criminal consequences for the illegal placement, but the child's welfare can still override that illegality for the purpose of making a final necessary order.
Precisely. The law punishes the illegal act, but retains flexibility to secure the child's welfare if that's the best outcome. Our source gives several case examples illustrating how courts have dealt with this. Re-C, a minor, adoption application, 1992 FAM Law 538, Re-MW 1995 2 FLR 7259, Re-G 1995 1 FLR 403, and Re-C Adoption Legality 1999 1 FLR 370.
So cases going back a bit, but establishing the principle.
Yes, these cases show the courts navigating situations where unlawful placements occurred, confirming that while the placement was illegal, the court could still make the adoption order after considering all the circumstances and, importantly, obtaining the required dispensation.
These cases underline the principle that ultimately, even with procedural irregularities, the child's welfare and the need for permanence can guide the court's final decision. Good to remember. Let's turn our attention now to the specifics of eligibility. Who is legally eligible to be adopted under the ACA 2002 framework?
Okay, the rule is quite straightforward as outlined in our source. Any unmarried person under the age of 18.
Under 18 and unmarried, that's the key. Simple enough. What if someone is 18 or married?
Then they cannot be the subject of an adoption order under English law. Section 47, 8, and 9 of the ACA 2002 are explicit on this. An adoption order cannot be made if the child has reached 18 or is married.
Even if the application was made just before their 18th birthday.
Doesn't matter. The order itself can't be made once they hit 18. A child can be adopted very close to their 18th birthday, as confirmed in the case Reedy, a minor adoption order, validity, 1991 to FLR 1215, but the age limit is a strict barrier. The order must be made before they turn 18.
And what about a child who's been adopted before? Can they be adopted again?
Yes, Section 49 of the ACA 2002 confirms that possibility. An adopted child can be the subject of a subsequent adoption order, although this would likely be very rare, perhaps if the first adoptive placement tragically broke down.
Okay, our source material poses a question here. Why only a child under English law? What do you think that signifies?
Well, it ties directly back to that modern purpose of adoption that we discussed earlier.
Mhm.
Restricting eligibility to those under 18 reinforces that adoption is a legal process designed to establish a parent-child relationship and provide permanent care and legal status for someone who is still a minor.
It's about childhood.
Exactly. It's not intended as a way for adults to formalize relationships that aren't inherently parental in nature. It's about the protective function and establishing legal parentage during the period of childhood dependency.
That clarifies the who can be adopted part. Now, who is eligible to do the adopting? Our source tells us the ACA 2002 significantly expanded the categories compared to the old 1976 Act.
It certainly did, reflecting changing societal structures and the aim of finding families for children in diverse situations. Big changes here.
Let's start with couples. Who qualifies as a couple under the Act for adoption purposes?
Under Section 144 of the ACA 2002, a couple can be married in a civil partnership, or two people who are living together as partners in an enduring family relationship.
That last category was the big change, right? Including unmarried and same-sex couples.
Yes, that was a significant expansion from the previous law, which primarily focused on married couples.
Important to remember the definition of couple isn't just any two people, though.
Correct. As our source clarifies, the Act specifies that a couple for adoption purposes cannot be two people if one of them is a close relative of the child they wish to adopt. Such a situation would typically fall under the rules for sole applicants or specific in-family adoptions by relatives, not joint adoption as a couple.
What are the age requirements for applicants?
For couples adopting jointly, each person must be at least 21 years old, point 51.
Both have to be 21.
Yes, unless there's an exception. If one of the applicants is the natural parent of the child they are applying to adopt, as often happens in step-parent adoptions, that person only needs to be 18 years old, point 52.
Sure. Okay.
The other applicant in the couple, the step-parent, would still need to be 21.
What about single people applying to adopt?
A single unmarried person can apply to adopt, provided they are at least 21 years old. This was another important change, allowing more avenues for children to find families.
Can someone who is married apply to adopt the child alone without their spouse joining the application? Is that allowed?
Yes, that's possible, but only in very specific, defined circumstances. The court has to be satisfied that the applicant's spouse cannot be found, or is incapable of making the application due to ill health, or
Or they're separated?
exactly, that the spouses are permanently separated and living apart, and the separation is likely to be permanent. This prevents potential legal issues arising from a spouse not being part of such a significant legal step, basically ensuring the other spouse isn't just being ignored.
Makes sense. And what about one natural parent adopting the child to the exclusion of the other natural parent? Our source points out this is possible, but the court needs specific justification.
It is possible, yes, but it requires the court to be satisfied that the other natural parent is dead or cannot be found, or, and this is the important bit, that there is some other reason that justifies them being excluded from the legal parentage.
And the court has to record that reason.
Yes, if the court makes the order on this basis, it must specifically record the reason for excluding the other natural parent. This highlights that cutting off the other natural parent's legal link is a serious step requiring clear justification based on the child's welfare.
Are there cases on this?
Yes, cases like Ray C. 1986, Fam Law 360, and Ray B. Adoption by one natural parent to the exclusion of the other, 2001, 1 FLR 589, are examples where courts have considered and, in those instances, permitted this type of adoption based on the specific circumstances and welfare considerations.
So the court needs a very clear, welfare-based reason to effectively write the other natural parent out of the legal picture. And earlier we touched on step-parents and grandparents.
Yes. Well, as we'll discuss, special guardianship orders are often now the preferred route for many in-family arrangements.
The SGO, right.
Our source confirms that grandparents can still apply for and be granted adoption orders if the specific circumstances and the child's paramount welfare necessitate that level of legal permanence and severance from birth parents.
So adoption by grandparents isn't ruled out.
No. The recent case of Ree T., a child, refusal of adoption order, 2020, EWCA Civ 797, involving grandparents, confirms this remains a possibility, although it's rigorously assessed against alternatives like SGOs. Adoption would need to be shown as the better option for the child.
Our source asks us to comment on the extension of who can adopt. It seems this clearly aligns with that modern purpose we talked about, finding families for children in diverse living situations.
Absolutely. The expanded eligibility criteria are a direct reflection of the shift in focus from the needs of traditional prospective parents to the needs of children requiring permanence. It recognizes that stable, loving homes can be provided by a much broader range of family structures and individuals than previously acknowledged in law.
So widening the net.
It's about prioritizing the child's need for a permanent family, whatever that family looks like, provided they are assessed as suitable and the adoption is in the child's paramount welfare.
Okay, we know who can be involved and who's eligible. Now let's trace the steps before a court can even consider making that final adoption order. There are certain preliminary requirements that must be satisfied. It's a structured process designed to ensure suitability and stability.
That's correct. It's not a matter of simply applying to the court. There are statutory hurdles to clear first. One of the key requirements is the residence requirement, laid out in Section 42 of the ACA 2002.
Okay, the residence requirement, what does that entail?
It requires that the child must have had their home with the applicant or applicants for a specified period of time immediately before the application for the adoption order is formally made to the court.
So the child has to actually live there first.
Yes, for a set time. This period varies depending on the type of placement, reflecting the different ways a child might come to live with prospective adopters.
So it's essentially a legal test to ensure the child is settled and has an established home with the applicants before the permanent step of adoption is taken.
Precisely. It's about confirming a de facto relationship, and stability exists. It shows things are working on the ground. The specific required period depends on the circumstances of the placement.
Okay, what are the periods?
If the child was placed with the applicants by an adoption agency, a local authority or registered adoption society, the child must have had their home with them for a period of at least 10 weeks immediately preceding the application.
10 weeks for an agency placement. Seems quite short.
Relatively, yes, because the placement itself is a formal agency-approved process with checks already done.
Okay, what else?
For non-agency placements, which primarily include step-parent adoptions or adoptions by the partner of the child's parent, the required period is a continuous 6 months immediately before the application.
6 months for step-parents partners. Longer.
Yes. If the applicants are local authority foster parents who are seeking to adopt a child in their care, the child must have had their home with them for a continuous period of at least 1 year.
A whole year for foster parents.
Yes. And the Children and Families Act, 2014, specifically facilitated placements with foster parents with a view to adoption, acknowledging this pathway, often called fostering for adoption.
Okay, and the last one, relatives.
For other relatives, in what we term in-family adoptions, excluding step-parents partners, the requirement is that the child must have had their home with the applicants for a continuous period of at least 3 years within the previous 5-year period.
3 years out of 5 for these in-family adoptions by relatives. That seems like a considerably longer period than the others. Our source material asks us why there's such a long period here. Any thoughts?
It's a pertinent question. It's likely because these in-family living arrangements often begin less formally than agency or planned foster placements, maybe due to a family crisis.
Right.
The 3-year cumulative period within 5 years helps to demonstrate that there's a deep, established, and stable de facto family relationship and commitment that has stood the test of time.
Proving it's not just temporary.
Exactly. Ensuring permanence is being sought for a child who is already genuinely integrated into that family structure, even if the initial arrangement wasn't specifically planned with adoption in mind.
So establishing that period of residence is one preliminary hurdle. What about notice requirements? Is the court simply presented with an application?
No, there are formal notice requirements too, designed to involve the appropriate authorities in assessing the suitability of the proposed adoption, if it's an agency placement.
The 10-week one.
Yes. Then the adoption agency has a duty under Section 43 of the ACA 2002 to prepare and submit a detailed report to the court. This report covers the suitability of the prospective adopters and, crucially, must address the relevant welfare issues identified in Section 1.4 of the ACA 2002, the Welfare Checklist.
And who writes that report?
Well, it's the agency's report, but it's often compiled by or involves a CAFCAS officer, that's the Children and Family Court Advisory and Support Service, who investigates the family and proposed placement.
And for non-agency cases, like a step-parent adoption.
In those situations, the proposed adopters must give formal notice to the local authority of their intention to apply for an adoption order. That's under Section 442 and 3.
They have to tell the council first.
Yes, and within a specific time frame. Not more than 2 years and not less than 3 months before the date, they intend to make the actual application to the court.
A specific window.
Yes. Once the local authority receives this notice, they have a statutory duty to investigate the circumstances, assess the suitability of the applicants, and provide their own report to the court, again taking into account the welfare issues under S.14.
So, regardless of the pathway, either a detailed agency report or a local authority report is required to provide the court with essential information on suitability and welfare before it can proceed. And suitability itself is quite detailed.
Oh, yes. There are comprehensive regulations accompanying the ACA 2002 that specify the factors that adoption agencies must consider when assessing prospective adopter suitability. These factors are then addressed in the reports submitted to the court, covering everything from their health and lifestyle to their understanding of adoption and their capacity to meet a child's needs. It's thorough.
Now, our source material points out that in addition to residence, notice, and suitability, one of two key conditions must be satisfied before the court can make the adoption order. What are these critical conditions? This is Section 47, right?
Yes, under Section 47 of the ACA 2002, either the consent condition or the placement condition must be met, one or the other.
Let's clarify what the consent condition involves.
Okay, the consent condition means that each parent or guardian of the child must have given their consent to the making of the adoption order, or they must have given advance consent to the order, or they do not oppose the making of the order.
So they agree, or at least don't object.
Essentially, yes. But it's vital to remember that, as we'll discuss in detail shortly, parental consent can be legally dispensed with by the court under specific circumstances. That's the crucial bit.
And who counts as a parent here?
Specifically, it means a parent who holds parental responsibility for the child. So an unmarried father without PR wouldn't need to consent under this condition, though other issues arise.
Okay. And the placement condition?
This condition applies when the child has already been formally placed for adoption with prospective adopters under the legal framework of the Act, usually via a placement order. The placement condition is satisfied if the child has been placed for adoption with the applicants, with the consent of each parent or guardian, or with their advance consent, or where the court has dispensed with their consent to the granting of the placement order.
Ah, so this links back to the placement order process itself.
Exactly. This links back to the legal process of placing a child with prospective adopters prior to the final adoption order. If that was done correctly with consent or dispensing, the placement condition under S.47 is met.
So essentially, the court needs to be satisfied that either the necessary consents or dispensing conditions for the final order are in place, or that the child has already been legally placed for adoption, meaning the consent dispensing requirements for that placement order were met. One of those two must be fulfilled under S.47.
Exactly. They represent the two primary legal pathways for proceeding towards a final adoption order, both ensuring that the necessary permissions or legal justifications for overcoming the lack of consent are established before the final order is made.
And, as our source emphasizes, contrasting with some earlier reform ideas, the child's consent is not required under S.47. We flagged this earlier.
Yes, this is a specific point of note. While the child's wishes and feelings are a crucial part of the court's welfare consideration, particularly under the checklist, their legal consent is not a prerequisite for the court to make the adoption order under S.47.
Fascinating how some reform ideas were taken on board and others weren't in the final act. Shows the complexity of drafting this stuff. Okay, assuming those preliminary requirements are met residence, notice, suitability, and one of the conditions under S.47, the court can now consider making the final adoption order under Section 46(1) of the ACA 2002.
Right now we're at the decision-making stage, and this is where the court applies the core principles that guide its decision-making. A really significant principle is that the court will only grant an adoption order if it is satisfied that it is justified in all the circumstances, and crucially, that no other order will do.
No other order will do. That phrase carries immense weight. Our source material highlights Re B as a key case associated with this principle, although it predates Re BS, which elaborated it further. It signals that adoption isn't the default. It must be demonstrably the only appropriate route.
Precisely. It imposes a strict requirement on the court to consider all realistic alternatives and conclude that none of them can sufficiently meet the child's needs and secure their welfare in the same way that adoption can. It positions adoption as a measure of last resort when lesser interventions are inadequate. We'll come back to this when we talk about Re BS.
And leading that assessment of what is necessary is the most important principle of all, enshrined in Section 1(2) of the ACA 2002. The child's welfare is the paramount consideration of the court.
Paramount. This was a pivotal change introduced by the ACA 2002, while the old 1976 Act said welfare was the first consideration.
First among equals, perhaps.
Maybe. But making it paramount brings adoption law into line with the Children Act 1989 framework. It means that the child's welfare, considered throughout their life, is the overriding factor that the court must prioritize above all other considerations when making its decision.
So it's not just weighted heavily. It sits at the very top of the hierarchy of factors. It trumps everything else.
Exactly. While other factors are considered, if there is a conflict between the child's welfare and other interests, like parental rights, for example, the child's welfare must prevail. Our source notes that this concept of paramount welfare is an established international principle, although applying it in complex, real-life scenarios can sometimes lead to challenging decisions. It's not always easy to determine what welfare truly demands.
Another vital principle from Section 1 is the no-delay principle, ACA 2002.
Yes, this principle recognizes that uncertainty and protracted legal proceedings are inherently harmful to children. Delay is the enemy of child welfare in these cases.
Right.
It mandates that the court and the adoption agency must avoid delay in the proceedings because any delay is considered likely to be prejudicial to the child's welfare. This is consistent with the requirement for prompt hearings under Article 6 of the ECHR, right to a fair trial within a reasonable time, and the equivalent no-delay principle in the CA 1989 as reinforced by cases like Raisey, Adoption, Disclosure to Father, 2005, EWHC 3385.
Delay can hold up a child finding a permanent home or resolving their legal status, which is obviously not good for their stability.
Absolutely. Stability and timely decision-making are critical for a child's emotional and psychological development. To help courts and agencies determine what is in the child's best interest within that paramount welfare framework, they are required to apply the welfare checklist, detailed in Section 1(4) of the ACA 2002.
This is a list of specific factors they must consider, the adoption checklist.
Yes, it's a structured way to ensure all relevant aspects of the child's situation are taken into account. It's similar in structure to the CA 1989 checklist, but has specific points relevant to adoption. The S114 checklist requires consideration of...
Let's run through them quickly.
Okay. A, the ascertainable wishes and feelings of the child concerned, considering age and understanding. B, his particular needs. C, the likely effect on him throughout his life of having ceased to be a member of the original family and become an adopted person.
That's a big one, the lifelong effect.
Huge. D, his physical, emotional, and educational needs. E, his background, race, culture, language, religion, and any other characteristics the court thinks relevant. F, the relationship he has with relatives and any other relevant person.
Like foster carers, maybe?
Could be, yes. G, the value to him of that relationship, any harm which he has suffered or is at risk of suffering, any change in his circumstances, and J, where an agency is involved, the recommendations of the adoption panel.
That's a comprehensive list. Point C, about the likely effect throughout life of ceasing to be a member of the original family, is particularly poignant.
It is, and it's one of the most adoption-specific points. It forces the court and agency to explicitly consider the lifelong impact of that legal severance, including the potential importance of maintaining some form of connection or understanding of their origins, which links directly to post-adoption contact.
And while the child's wishes are on the checklist and important, we noted earlier that their legal consent is not required for the adoption order itself.
That's correct. The court will give weight to the child's wishes and feelings depending on their age and maturity. And it would be highly unusual for a court to make an order against the strong wishes of an older, competent child. But legally, their consent isn't a barrier under S.47.
Our source also mentions a requirement related to a child's background that used to be a more rigid factor, something about matching.
Yes, the original ACA 2002 required agencies and courts to give due consideration to a child's religious persuasion, racial origin, cultural and linguistic background when making placement decisions. This was seen as promoting identity preservation.
But that changed.
Yes, this was repealed by the Children and Families Act 2014. The concern was that in some cases, it was being interpreted in a way that could potentially override the paramount welfare principle.
How so?
By delaying placements or limiting suitable families based primarily on these background factors, even if a perfectly good family of a different background was available. The repeal ensures that while these aspects of a child's identity are still relevant and considered under the general welfare checklist particularly, they cannot on their own dictate a placement decision if it conflicts with the child's overall best interests, especially the need for a timely, permanent placement.
So, still relevant as part of identity, but not a rigid criterion that could potentially disadvantage a child needing a home. Welfare is paramount over matching factors.
Exactly. Welfare remains paramount, and background is one factor within that overall assessment.
Finally, there's the no-order principle from S.16 of the ACA 2002.
Ah, yes, the do-nothing option almost. This principle requires the adoption agency and the court to actively consider the full range of available orders, not just adoption, but also orders under the Children Act 1989, like child arrangements orders, special guardianship orders, care orders. They must only make an order if they are satisfied that doing so would be better for the child than making no order at all.
Better than the status quo.
Yes. This mirrors the CA 1989's no-order principle and acts as a safeguard against unnecessary state intervention.
It means the court shouldn't just assume an order is needed. They must be convinced that intervention, and specifically the proposed order, will improve the child's situation compared to leaving things as they are or making a different, less interventionist order.
Precisely. If a less interventionist order, like a special guardianship order, could equally secure the child's welfare, the court should favor that, which leads us nicely into discussing alternatives.
That's a perfect segue. The ACA 2002 didn't just update adoption. It also introduced a significant alternative route for providing permanence for children, the Special Guardianship Order, SGO.
Yes, SGOs were introduced by the ACA 2002 and inserted into the Children Act 1989 via the new sections 14A to 14G, a really important development.
And the goal?
The explicit goal was to provide a legal status for carers that offered more security and permanence than a standard child arrangements order, CAO, but crucially, without the finality and complete severance of legal ties that comes with adoption.
Okay, so what's the fundamental difference between an SGO and adoption? Let's nail this down.
The most crucial difference is that an SGO does not legally extinguish the relationship between the child and their birth family. The birth parent remains the child's legal parent.
But the special guardian gets PR.
Yes, the special guardian does acquire parental responsibility for the child, and they can exercise this parental responsibility to the exclusion of any other person with PR, including the birth parents.
Meaning they can override the parents?
In day-to-day decisions, yes. It allows them to make those decisions and provide a stable home without constant consultation or interference. But the birth parent remains the child's legal parent, and certain relationships, like inheritance from birth parents, can remain.
So while the SGO gives the carer primary legal authority, it maintains a legal link to the birth family, unlike adoption, which severs it completely. When does a court typically favor an SGO over adoption?
The core consideration, as always, is which order better serves the child's welfare throughout their life. That's the test under S.1 CA 1989. This decision very frequently hinges on the desirability of ongoing contact or continuing relationship with the birth family.
So contact is key.
Often, yes. If maintaining some level of legal tie and facilitating contact with birth parents or wider birth family is deemed to be in the child's best interests, an SGO is often the preferred route because it accommodates this much more naturally than adoption. Adoption makes contact legally more difficult to enforce.
Our source material highlights that SGOs are now frequently the preferred option, particularly in interfamily placements.
That's right. In cases where grandparents, aunts, uncles, or other relatives are providing long-term care for a child, an SGO is often seen as a more appropriate legal tool than adoption. It gives the relative carers the necessary PR to care for the child and provide stability, but it avoids the drastic step of legally cutting off the birth parents entirely.
Which might be better for the child's identity.
Exactly, especially if contact or a relationship with the birth family is part of the care plan or desired by the child.
And our source lists several cases that illustrate this trend of favoring SGOs in these contexts. SVB and Newport City Council, RE-K 2007, FLR 1116, RE-AJ, Adoption Order or Special Guardianship Order, 2007, EWCA Civ 55, RE-MJ, A Child, 2007, EWCA Civ 56, A Child, 2018, EWCA Civ 2007.
That's quite a list. These cases collectively demonstrate the court's careful consideration of XGOs as a robust alternative. For example, RE-AJ emphasized that SGOs offer greater flexibility for contact than adoption. RE-PS described the SGO as a less interventionist option that can still provide the necessary stability if permanent severance isn't essential for the child's welfare.
But parents can still object.
Yes. RE-WB serves as a reminder that birth parents can still object to SGOs, and the court must consider those objections within the welfare framework, just like with adoption.
So the SGO is seen as a less drastic form of intervention compared to adoption.
Absolutely. Our source describes SGOs as being considered less interventionist than adoption. They provide permanence and PR, but are viewed as a halfway house between adoption and a standard child arrangements order under Section 8 of the CA 1989.
A CAO being an even less formal order, primarily regulating residence and contact, but not conferring the same level of PR as an SGO or adoption. Not as much power for the carer.
Exactly. A CAO offers less permanence and less ability for the carer to make unilateral decisions compared to an SGO. While SGOs are intended to be long-term and provide stability, they aren't strictly irrevocable like adoption orders generally are.
They can be undone.
There's a legal process for applying to discharge an SGO, although it typically requires obtaining leave permission from the court to even make the application. This adds a layer of protection against frivolous challenges, as seen in RE-M, Special Guardianship Order, leave to apply to discharge, 2021 EWCA Civ 442. So, possible, but not easy.
Let's revisit step-parent adoptions for a moment. We noted that while the CA 1989 offers simpler ways for a step-parent to gain PR, some families still pursue adoption for that full legal integration.
Yes, gaining PR under the CA 1989, maybe by agreement or an S.8 order or even an SGO, is less complex than adoption, but it doesn't achieve that full legal parentage shift of S.67 ACA 2002. Some families want that complete legal tie. If a step-parent adoption is sought, but the other natural parent, who isn't living with the child, doesn't consent, the court has to consider dispensing with their consent under Section 512 of the ACA 2002.
And how does the court approach dispensing with that non-resident parent's consent in the step-parent adoption? What's the test?
This is fundamentally a matter of proportionality. The Court of Appeal clarified this approach in RE-P, A Child, 2014 EWCA UoL M74, and reaffirmed it in RE-L, A Child, Step-Parent Adoption, 2021 EWCA Civ 801.
Proportionality again, like with human rights.
Exactly. The court must balance the proposed interference with the non-consenting parent's Article 8 rights, right to family life, and potentially the child's Article 8 rights with the child's welfare and the benefits of the proposed adoption for the child. Failure to apply this proportionality test correctly might not automatically invalidate an order, but RE-P and RE-L confirm it is the legally mandated approach.
What kind of factors might make a step-parent adoption, and thus dispensing with the other parent's consent, more likely to be considered a proportionate step?
Our source extracts key factors derived from these cases that tend to reduce the level of interference with the non-consenting parent's Article 8 rights, making dispensing with consent more likely.
Okay. Like what?
Where the non-consenting parent B has had little to no care of the child or has not actively asserted their parental responsibility. Basically, they haven't been involved.
Right.
Where parent B has had very limited or no contact with the child.
Okay.
Where there is a strong, established, and stable family unit consisting of the parent and the step-parent, and where de facto family ties, meaning they function as a family, in reality have existed for a significant period. The step-parent is already acting like a parent.
So if the absent parent hasn't really been involved, and the step-parent is already a fully integrated and functioning part of the child's everyday family life, the court is more likely to view the step-parent adoption as a proportionate step for the child's welfare, despite the lack of consent from the other parent.
Exactly. The less active the existing family life with the non-consenting parent, the less intrusive the legal severance via adoption is considered to be from a human rights perspective, and the more likely the court is to prioritize formalizing the child's de facto family unit with the step-parent if adoption is deemed better than an SGO or CAO for welfare.
Okay, let's dedicate significant time now to what is arguably the most legally contentious and emotionally charged aspect of adoption law: consent. This is where it gets really tough.
It really is. This area involves complex legal tests and profound human rights considerations, particularly when consent is not given freely.
First off, before a final adoption order, a child must be legally placed for adoption. Our source discusses consent to placement under Section 19 of the ACA 2002.
That's right. Except in very specific circumstances, a child needs to be legally placed for adoption with prospective adopters before the application for the final adoption order can be made. This placement requires either the consent of each parent with parental responsibility or a placement order granted by the court.
A court order overriding consent.
Yes. As highlighted in REPB Placement Order 2006 EWCA Civ 1016. The Children and Families Act 2014 also specifically allows children to be placed with approved foster parents with a view to adoption, the fostering for adoption route.
Consent to placement under S.1 time applies to children over 6 weeks old.
Correct. For children older than 6 weeks, placement by consent is possible. The agency must be satisfied that every parent or guardian has given consent to the placement and has not withdrawn it. Section 52 of the ACA 2002 details the requirements for consent. It must be unconditional and in a prescribed legal form.
Prescribed form, like a specific document.
Yes, specific wording and witnessing requirements to ensure the parent understands what they're agreeing to. Parents can also give advance consent for the eventual adoption order at this stage, meaning they agree now to the final order being made later.
So parents can consent to the initial placement. Can they change their mind and withdraw that consent?
Yes, they retain the right to withdraw their consent to placement up until the application for the final adoption order is made to the court.
Up until the final application.
Yes. If they withdraw consent after the child has been placed, the child must be returned to the birth parents within 14 days. If they withdraw consent before the child is placed, the return must happen within 7 days. So withdrawal has immediate consequences for the placement.
What is the process if the parents don't consent to placement or withdraw their consent, but the local authority believes adoption is in the child's best interests?
Okay, in that scenario, the local authority can apply to the court to dispense with consent under Section 52 of the ACA 2002. The court has the power to do this if it is satisfied that the welfare of the child demands it.
Welfare of the child demands it. That sounds like the paramount welfare principle coming into play to override parental rights. That's the key test.
That is the key statutory test for dispensing with consent. And our source notes that, in truly exceptional circumstances, a court can even dispense with consent and make a placement order without giving notice to the parents, as seen in Relinquished Baby Risk of Domestic Abuse, 2018 EWHC 1981, FAM, where severe risks like domestic abuse were present. But this power is used very cautiously.
So usually parents are involved.
Yes. As confirmed in cases like repeat adoption, parental consent 2008 EWCA Civ 535, once adoption is determined to be in the child's paramount welfare interests, the court can legally dispense with parental consent using that S.52 test. And, as we've noted, the child's own consent is not required for dispensing with parental consent or for the adoption order itself.
But overriding parental consent raises significant human rights issues, particularly Article 8, the right to respect for private and family life. This is where some landmark cases come in, right? The really big ones.
Absolutely. This is the context in which the cases of ReB 2013 UKSC 33 from the Supreme Court And Re BS 2013 EWCA Civ 1146 from the Court of Appeal became absolutely crucial. These cases profoundly impacted how courts approach non-consensual adoption and care orders, precisely due to the need to comply with the HRA in 1998 and Article 8.
You absolutely have to know REBI and REBS.
You must know these cases if you're studying this area. They are foundational to current practice regarding dispensing with consent. They changed everything.
Our source emphasizes that these cases made it abundantly clear that non-consensual placement orders and care orders are measures of last resort. They are only legally justifiable when nothing else will do.
Nothing else will do. These cases describe such orders as severe and interventionist steps. In Re BS, Sir James Munby, the president of the Family Division at the time, drawing on the Supreme Court's judgment in Re B and European Court of Human Rights case law, stressed that severing family ties through adoption without parental consent is a draconian step.
Draconian. Strong word.
Very. He said it requires the highest level of evidence to justify. He unequivocally stated that courts must adopt the least interventionist approach that is compatible with the child's paramount welfare.
Draconian step, highest level of evidence, least interventionist approach. These are powerful terms that signal the gravity of dispensing with parental consent. This isn't taken lightly.
Not at all. And Munby P. highlighted key points from the Supreme Court's decision in Re B that are essential for understanding this stringent approach.
Okay, what were those key points from REBI?
1. He reiterated that the child's paramount interests, while overriding, include being brought up by their natural family. This is not a separate interest. It's a fundamental aspect of the child's welfare to be considered.
So being with birth family is part of welfare itself?
Yes. 2. The court has a statutory duty to consider all realistic options for the child's care. You cannot just focus on adoption. You must genuinely and rigorously evaluate every viable alternative, including care within the extended birth family or long-term foster care. A proper comparison is needed.
And 3.
3. The court's assessment of the parent's capacity to care for the child must include considering the support that public authorities, like the local authority, could reasonably offer them to help them care for the child.
So the court must ask, can the parents provide good enough care with the support that's available, not just on their own?
Exactly. It's not just an assessment of their current ability in isolation, but their potential with necessary support. These principles require a deep dive into the facts of each case and a rigorous comparison of options.
And how did the case of CMV Blackburn fit into this?
The case of CMV Blackburn with Darwin Borough Council 2014 EWCA Civ 1479 further considered how these principles should be applied in practice. The mother appealed against a placement order, arguing that because the local authority's plan involved searching for adopters for a period and having a backup plan of long-term foster care if adopters weren't found, the placement order couldn't truly be a measure of last resort where nothing else will do. She was saying, look, you have another option.
But the Court of Appeal dismissed her appeal, clarifying the meaning of nothing else will do.
Yes. The Court of Appeal clarified that REBI and REBS did not create a new legal test or a new presumption against adoption. Instead, they explained the existing law, the process the court must follow, and the standard of evidence required to justify such a serious step. They helpfully outlined a 5-part exercise that courts must conduct when deciding whether to make a placement order.
Okay, a 5-part exercise. What are the steps?
1. The court must undertake a thorough welfare analysis of each realistic option available for the child's future care. This involves applying the S.14 welfare checklist to each option and drawing up a balance sheet of the likely benefits and detriments for the child under each scenario.
Weighing up the pros and cons of each option.
Yes. 2. The court must then compare these analyses of each realistic option against each other. 3. Based on that comparison, the court must make a welfare evaluation or value judgment under S.12 to decide which single option safeguards the child's welfare throughout their life better than any other.
Finding the best option for the long term.
4. This welfare decision then informs the statutory test for dispensing with consent under S.213b for placement orders and S.52 for adoption orders. The court asks, is it necessary to dispense with consent based on this paramount welfare evaluation? 5. Finally, the court must perform a proportionality evaluation. Is the welfare conclusion reached that this specific order is necessary for the child's welfare, a proportionate interference in the family life of the child and parents, considering Article 8?
And that proportionality evaluation is what nothing else will do represents. It's the outcome of that process.
Exactly. CMV Blackburn made it very clear that nothing else will do is not a standard of proof like beyond reasonable doubt. It is the conclusion that the court reaches through a process of careful, deductive reasoning.
So it's the answer, not the question.
Precisely. It means that after conducting the five-part exercise, analyzing, comparing, and evaluating all realistic options, the court concludes there is no other comparable option that can equally meet and safeguard the child's welfare throughout their life. It doesn't mean there are zero other theoretical options, but none that are comparably beneficial for the child's long-term welfare.
This sounds like a very rigorous process judges must follow, especially when approving care plans that involve adoption. They can't just rubber stamp it.
It is. It means that even within care proceedings, when a local authority proposes adoption as part of the child's long-term care plan, the judge must apply these specific adoption welfare considerations, including the full proportionality analysis required to dispense with parental consent. This ensures that the decision to sever family ties isn't made lightly.
Okay, let's formally define the placement order under Section 21 of the ACA 2002. What does it do?
A placement order is an order made by an authorized court authorizing a local authority to place a child for adoption with any prospective adopters who may be chosen by the authority in the future.
So it gives permission to place, even if they haven't found the specific family yet.
Yes. This order is typically made when a child is already subject to a care order and there's no parent or guardian able or available to provide long-term care.
So the local authority first needs to meet the threshold criteria for a care order under S.31 of the CA 1989, the significant harm threshold.
Yes, that initial threshold, showing the child is suffering or is likely to suffer significant harm attributable to the care being given or likely to be given, must be met. In addition, the court must be satisfied that each parent or guardian has consented to the child being placed for adoption, or that their consent has been dispensed with according to the rigorous test we've just discussed, based on welfare demanding it and the RBS principles.
Does the local authority always have to apply for a placement order in these circumstances?
Not always. Under Section 22(1) of the ACA 2002, a local authority may have a duty to apply for a placement order if specific conditions are met, like having a care order and determining adoption is in the child's welfare. However, they also have a discretion to apply under Section 22(3) in other circumstances.
What's the difference between the duty and discretion?
A duty means they must apply. If the statutory criteria are met, they have no choice. Discretion means they can choose to apply based on their professional judgment and welfare assessment, even if not strictly mandated.
Got it. What are the legal effects once a placement order is made?
A placement order gives parental responsibility for the child to the local authority and to any prospective adopters the child is placed with.
So shared PR.
Yes, shared between the LA and the prospective adopters once placed. However, it's crucial to remember that the birth parent's parental responsibility is not extinguished at this stage. It only ends when the final adoption order is made.
So parents still legally have PR under a placement order?
Yes, technically, but the LA and adopters can exercise their PR to the exclusion of the parents. The placement order remains in force until it's revoked. The child is automatically a party to the placement order proceedings and has a children's guardian appointed to represent their interests. Placement orders can be varied, typically if the responsible local authority changes.
What if a placement breaks down after a placement order is made? Can the parents get the child back?
The adoption agency or local authority has the power to remove the child from the placement if it is not working out. Birth parents do not have the legal right to demand the child's return under Section 30 simply because a placement has failed. Their PR doesn't give them that right once a PO is in place.
Right. And there are restrictions while the PO is active.
Yes. While the placement order is active, certain restrictions apply under Section 28, 2, and 3, for example. You cannot change the child's surname without the court's permission, and you cannot take the child out of the UK for more than 1 month without permission.
And if the PO is revoked?
If a placement order is ultimately revoked, any existing care order or CA 1989 LF.8 orders relating to the child automatically cease to have effect.
What about babies under 6 weeks old? Our source mentions a specific rule for them.
Yes. For a child less than 6 weeks old, an agency can place the child with prospective adopters with the voluntary agreement of the parent or guardian, S219. However, the agency does not have the power to determine the extent to which parental responsibility can be exercised by either the birth parents or the prospective adopters in this particular scenario, unlike placements for older children. It's a slightly different legal footing for very young infants placed by agreement.
Our source also includes a prompt to think about the rights of an unmarried father in adoption proceedings and whether they should have more rights. We touched on this.
Yes. Under the ACA 2002, as drafted, an unmarried father's consent to placement or adoption is only legally required if he holds parental responsibility for the child. If he doesn't have PR, his consent isn't strictly necessary under the statute.
But human rights law affects this.
Exactly. Case law developed under the HRA in 1998 has established that where an unmarried father has demonstrated significant commitment to the child, failure to notify him of adoption proceedings or consult him could constitute a breach of his Article 8 rights, even if his formal consent isn't needed. Judges are generally expected to ensure natural fathers are informed of proceedings unless there is a very compelling reason not to, often linked to safety concerns for the mother or child.
So, while the statute might not require his consent without PR, human rights law and case precedent push for his involvement if he's been part of the child's life. Practice has evolved.
Exactly. The courts strive to reconcile the statutory framework with the realities of family life and human rights principles.
Okay, we've covered consent to placement and placement orders. What about consent to the adoption order itself, the final step?
Right, this is the final stage, consent. Section 52 of the ACA 2002 states that consent given for the adoption order within the first 6 weeks of the child's birth is legally ineffective. It cannot be relied upon. You can't consent properly straight after birth.
A cooling off period, effectively.
Sort of, but crucially, if consent was given for a placement order, that consent is typically deemed effective for the final adoption order as well. Section 52(3) says consent to placement is consent to adoption unless specified otherwise.
Ah, okay. So consent to the PO usually covers the final AO too.
Yes.
Yeah.
This is why, in many cases, the main legal battle over consent happens at the placement order stage. If the LA gets a PO, they usually don't need separate consent for the AO.
Right.
If consent is given specifically to the adoption order, maybe in a step-parent case without a PO, S.523 requires it to be in a prescribed form. And here is another absolutely critical point. Once consent to the adoption order has been properly given or dispensed with via a PO, it cannot be unilaterally withdrawn by the birth parents.
They can't just change their mind and stop the adoption at the last minute?
Not by simply withdrawing consent, no. If a parent who previously consented, or whose consent was dispensed with via a placement order, wants to stop the final adoption order being made, their only legal route is to seek leave to oppose the final adoption order application from the court.
Leave to oppose. Permission to fight it.
Yes. This is under Section 47, 5, and 7 of the ACA 2002.
And this is where the principles from Re-B and Re-BS are fundamental again, applying to the court's decision on whether to grant that leave to oppose.
Absolutely. The court applies a stringent test to decide whether to give permission for a parent to oppose the final order. It's guided by the paramount welfare principle and the need to avoid disrupting the stability of the placement. The test involves considering if there has been a significant change in circumstances since the PO was made, and if the parent has a solid, arguable case with a real prospect of success.
So it's not just about wanting the child back.
No, far from it. The principles from Re-B and Re-BS, the nothing else will do test, the consideration of realistic alternatives, the assessment of parents' capacity with support, the proportionality inform whether it is appropriate to grant leave to oppose the final order. If leave is refused, the adoption order can be made without further opposition on grounds related to consent.
It sounds like a very high bar for parents to clear if they've already been through the placement order process or previously consented. Really hard to reopen it.
It is. The law places significant weight on the stability and welfare assessment that led to the placement. Allowing opposition at the final stage could reintroduce uncertainty, which is considered prejudicial to the child's welfare. However, our source mentions recent cases that continue to explore these areas, indicating it's still a live issue.
Which cases?
Cases like Prospective Adopters v. LB Tower Hamlets 2020 EWFC 26, K Children Placement Orders 2020 EWCA Civ 1503, Re-CD A Child 2020 EWCA Civ 501, L, Adoption, Identification of Possible Father, 2020 EWCA Civ 577, FS, A Child, Placement Order 2021 EWCA Civ 1212, and IA Children, Revocation of Adoption Order 2021 EWCA Civ 1222.
That's a lot of recent case law indicating this area is still being refined and applied in practice. Our source specifically highlights Re-Y, Leave to Oppose Adoption, 2020 EWCA Civ 1287.
Ah, yes, Re-Y. There, the Court of Appeal granted leave to oppose despite a local authority appeal, raising interesting issues around access to justice, including for disabled litigants participating in remote hearings during the pandemic.
So Rewise shows that while the test for leave is stringent, it's not impossible to meet, and the court retains a discretion informed by the need for fairness and consideration of the individual circumstances, especially significant changes.
Exactly. It's a high bar, but not necessarily insurmountable if the criteria are met.
Our source includes activities that prompt deeper thought on these consent provisions. Activity 12.7 asks you to read Red P, Adoption, Leave Provisions, 2007 EWCA Civ 616, and consider, in light of the Rebbe principles that came later, whether leave to oppose should have been granted in that case.
That's a fantastic exercise in applying the principles. It encourages you to look at the facts of REPI 2007 and then retrospectively analyze the decision through the lens of the stricter proportionality and nothing else will do test articulated in REBS. Would the outcome have been different? Would the reasoning have been framed differently? Really good critical thinking practice.
And Activity 12.8 poses a broader, almost philosophical question. Does the current law on consent adequately protect birth parents' interests? Or does it protect them too much, potentially to the detriment of children needing permanence?
Oof. That question gets to the very heart of the balancing act in adoption law. It's the core tension. On one hand, the RE-B and RE-BS principles significantly strengthen the position of birth parents by making non-consensual adoption a true last resort, requiring thorough assessment of alternatives and support that suggests parental interests are heavily considered.
But
On the other hand, the inability to withdraw consent easily and the stringent test for leave to oppose at the final stage mean that once the court has made a decision based on the child's paramount welfare, the parent's ability to halt the process is significantly curtailed. Some might argue this limits parental rights too much in favor of the child's stability and the adopter's security.
finding that balance.
It's a legitimate tension within the law with valid arguments on both sides. There's no easy answer.
It truly is a reflection of the difficult decisions involved, balancing fundamental rights and needs within families. We've talked about making the order and the legal framework. Now let's look at what happens after the adoption order is granted post-adoption life. Historically, adoption often meant a complete, clean break secrecy and no contact with the birth family. That was the old model, right?
That was the prevailing model for a long time, particularly for infant adoptions. The idea was to integrate the child fully into the new adoptive family without the complications or potential confusion of ongoing contact with the birth family. A fresh start.
But our source material points out that with the changing landscape of adoption, particularly more adoptions involving older children who have existing memories and relationships with their birth families, post-adoption contact has become a much more relevant and often desirable consideration.
Absolutely. For a child who has lived with their birth family for several years, abruptly severing all contact might be profoundly detrimental to their sense of identity, their understanding of their history, and their overall emotional well-being. It's a much more complex picture than with a young baby who has no memory of their birth family.
Despite this increased relevance, courts have historically been quite reluctant to order contact with birth relatives against the wishes of the adoptive parents once the adoption order has been made. Why was that?
That reluctance stemmed from a desire to protect the integrity and stability of the new adoptive family unit and to empower the adoptive parents to make decisions about the child's upbringing, including who they have contact with, without interference from the court or birth family. Ordering contact against the adopter's wishes was seen as potentially undermining the permanence and authority of the adoption.
Undermining the irrevocable nature, perhaps?
Perhaps. The ACA 2002 itself required the court to consider contact arrangements when making the order, but it didn't create a presumption that contact should happen. It was just a factor on the checklist.
But the Children and Families Act 2014 introduced a new section that provides a clear statutory basis for post-adoption contact orders.
Yes, Section 51A of the ACA 2002, inserted by the 2014 Act, created a specific legal mechanism for dealing with contact after an adoption order has been made. This was a significant addition.
How does that section work? What can the court do?
Under Section 51A2, when a court makes an adoption order or at any time afterwards, it may make an order regarding contact. This order can either require the adopters to allow contact between the child and a specified person.
Like ordering visits?
Yes, covering various forms of contact like visits, stays, letterbox contact, or other interactions. Or it can prohibit a specified person from having contact with the child. So it works both ways, allowing or preventing contact.
Who are the kinds of people who could potentially be named in such a contact order? On SMI51A, is it just birth parents?
No, Section 51A3 provides a broad list. It includes anyone who, before the adoption, would have been related to the child by blood, marriage, or civil partnership. So siblings, grandparents, aunts, uncles. It also includes any former guardian of the child, anyone who held parental responsibility for the child immediately before the adoption order was made, certain applicants under Section 26, which deals with contact during a placement for adoption, and importantly, any person with whom the child has lived for a period of at least 1 year, calculated cumulatively within the 5 years preceding the application for the contact order.
So it's not just immediate birth family, but also significant carers or wider relatives could potentially get or be denied contact under this section?
Potentially, yes.
Yeah.
Who can apply for a Section 51A contact order?
Under Section 51A4, the person who applied for or holds the adoption order can apply. The child themselves can apply, or any other person can apply if they first obtain the court's leave, permission to make the application.
So not just anyone can apply. You need permission first.
Exactly, unless you're the adopter or the child. And what does the court consider when deciding whether to grant leave to someone else to apply for a contact order?
Section 51A5 lists the factors. The court must consider the potential risk that the proposed application itself might disrupt the child's life or cause harm, referencing the definition of harm in the CA 1989, the nature of the applicant's connection with the child, and any representations made to the court by the child or the adopters.
So the court acts as a gatekeeper.
Yes, it reflects the court's gatekeeping role to protect the stability of the adoptive placement from potentially disruptive applications.
Can the court make a contact order even if no one has applied for one?
Yes, under Section 51A6, the court has the power to make a contact prohibition order on its own initiative when it is making an adoption order if it deems it necessary for the child's welfare, say to prevent a potentially harmful relative from trying to make contact later.
Our source highlights something crucial about S.8 CA 1989 Child Arrangements Orders, CAOs, in the context of post-adoption contact. What's the relationship?
Yes, Section 51A of the ACA 2002 is very specific. It states that where Section 51A applies, i.e. contact regarding an adopted child, a child arrangements order under Section 8 of the CA 1989 cannot be used to regulate contact between the child and any person who could potentially be named in a Section 51A order.
So you have to use S.51A.
Yes. This means S.51A is the dedicated specific statutory route for dealing with contact issues after an adoption order has been made, preventing recourse to the broader CA 1989 provisions for these specific individuals. It channels everything through the adoption-specific contact regime.
What about contact before the final adoption order is made, while the child is placed for adoption under a placement order?
Yeah.
Can relatives use S.8 then?
No. During the period while a placement order is in force, S.8 CAOs cannot be made by other parties either. However, Section 26 of the ACA 2002 allows the court to require the person with whom the child is living, the prospective adopters, to allow the child to have contact with a person identified in the placement order.
But is that common? Ordering contact against prospective adopters' wishes?
Even at this stage, while the child's welfare is paramount, the court ordering contact against the wishes of the prospective adopters is considered extremely unusual, as stated in the case of Oxfordshire County Council VX 2010, EWCA Civ 581, the stability of the placement is usually prioritized.
It seems the courts are very protective of the prospective adopter's position, both before and after the final order regarding contact. But there are nuances, like the RE-PM, a child, 2013 EWHC 1838 case mentioned.
Yes, in RE-PM, the court did make a limited contact order in favor of a grandmother, even against the prospective adopter's initial position. This was based on the specific circumstances and the importance the court placed on the child's relationship with a sibling and wider extended family ties for that child's welfare.
So it can happen if welfare demands it.
It shows that while ordering contact against adopters' wishes is unusual, it can be done if the child's paramount welfare clearly dictates it. And RE-B, a child, post-adoption contact, 2019 EWCA Civ 29, is noted as a recent case reviewing the law in this area.
What did that say?
That case reinforced that Section 51A was intended to provide a specific framework for post-adoption contact that recognizes the unique status of adoptive families and gives significant weight to the adopter's views, while still allowing the court to make orders where required for the child's welfare. It confirmed S51A didn't really weaken the adopter's position compared to the previous case law.
Okay. Beyond physical contact, there's also the broader concept of the child's right to know about their origins. How does English law address this for adopted people?
The law recognizes that adult adoptees have rights to information about their birth origins. From age 18 or from 16 with counseling, an adopted person can apply to the Registrar General for a copy of their original birth certificate.
Their original one, showing their birth parent.
Yes. They can also apply to the court for the names of the adoption agency that arranged their placement and the local authority that supervised it, as confirmed in RV Register General, X. P. Smith, 1991, 1 FLR 255.
Is that right? Absolute.
Yeah.
Can they always get it?
Our source notes that this right isn't absolute. Accessing the original birth certificate might be denied in appropriate rare cases, typically where it is deemed to pose a significant risk to a birth parent or perhaps the adopted person themselves, as was the issue in Ex parte Smith.
And is there a way for birth relatives who are interested in contact to signal that, like a register?
Yes, the Registrar General maintains the Adoption Contact Register, previously the Adoption Children Register. Birth relatives who wish to potentially have contact with an adopted person can record their details on this register.
And does the adopted person get told?
Information from this register is only shared with the adopted person if that person has also registered and given notice indicating a wish to contact their birth relatives, as illustrated in DV Registrar General 1997 1 FLR 715. These registers are not public records, protecting the privacy of both adopted people and birth relatives who do not wish for contact. It requires both sides to opt in.
Our source prompts further thought with Activity 12.9. Should a child have an unlimited right to know the identity of their natural parents?
Ooh, that question goes to the heart of balancing competing rights and interests. An unlimited right for a child to know their birth parent's identity from any age raises complex issues regarding the birth parent's right to privacy, especially if they have built new lives, maybe haven't told current partners, potential safety concerns in some cases, and the potential impact on the stability of the adoptive family.
It's not straightforward.
No. While the law increasingly recognizes the importance of identity for adopted people, the current legal framework balances the adult adoptee's right to information with safeguards for all parties. An unlimited right for a child, rather than an adult, would be a significant policy shift with wide-ranging implications.
It's clear this area of post-adoption life is continually evolving as we understand more about the long-term needs and identities of adopted individuals. We've mentioned human rights, particularly Article 8, the right to respect for private and family life, multiple times throughout this deep dive because they are so integral to modern adoption law. Let's specifically summarize the impact of the Human Rights Act, 1998, HRA 1998.
Okay. The HRA 1998 incorporates the rights from the European Convention on Human Rights, ECHR, into UK law, requiring courts and public authorities, like local authorities and adoption agencies, to act compatibly with these rights.
And adoption is a clear interference.
Absolutely. Adoption proceedings, especially those involving non-consensual adoption, represent a significant interference by the state with the Article 8 rights of the child, the birth parents, and often the prospective adopters as well. Family life is heavily engaged.
And as we've seen, the cases of Re-B and Re-BS are absolutely pivotal in demonstrating how human rights principles, particularly Article 8, reshape the legal landscape for dispensing with parental consent and making non-consensual placement and adoption orders. They are HRA cases in essence.
They really are. Early on, the European Court of Human Rights, ECTHR, in Strasbourg was cautious about non-consensual adoption. Cases like Johansen v. Norway, 1996, suggested such measures could only be justified by an overriding requirement flowing from the child's best interests, and even then, ongoing relationships and contacts should ideally be maintained where possible. There was a focus on maintaining links.
But the ECTHR later confirmed that adoption, even without parental consent, is permitted under the convention framework. It's not inherently a breach.
Yes. Later cases such as Soderback v. Sweden 1999 and Scott v. UK 2000 confirmed that permanent placement via adoption, even if non-consensual, can be a proportionate measure under Article 8. However, and this is the crucial part, these cases and the domestic courts interpreting them emphasize that for such an order to be compatible with Article 8, it must meet strict criteria.
Which are?
It must be a last resort and a proportional response to the child's situation.
And that is the direct link to the nothing else will do principle from Raby 2013 and the detailed proportionality analysis required by CMV Blackburn. The domestic courts basically adopted the Strasbourg tests.
Precisely. The domestic courts, guided by the HRA 1998, interpreted the ECHR requirements as demanding that rigorous analysis of alternatives, the assessment of parental capacity with support, and the five-part proportionality exercise must be undertaken to ensure that the profound interference with family life caused by non-consensual adoption is truly necessary and proportionate for the child's paramount welfare.
Another area where Article 8 has had a significant impact is regarding unmarried fathers. We flagged this earlier.
Yes, this is a clear example of the HRA leading to a change in practice based on rights. As we discussed, the ACA 2002 only requires an unmarried father's consent if he has parental responsibility. However, case law developed under the HRA in 1998 recognized that even without PR, an unmarried father who has a genuine, committed relationship with a child has Article 8 rights to respect for his family life with that child.
Even without PR, he has rights.
He has Article 8 rights if family life is established, yes. So failing to notify him of proceedings, even if his consent isn't required by statute, could breach his rights.
Which case established that?
The case of REH, Consultation of Unmarried Father, 2001 FLR 646, was influential here, suggesting that making an adoption order without notifying an unmarried father who had shown commitment could breach his Article 8 rights. This led to the practice, confirmed by the ECTHR and PC and SVUK 2002 to FLR 631, that judges are generally expected to ensure natural fathers are informed of adoption proceedings unless there's a very good reason not to.
And a mother just wanting confidentiality isn't usually enough.
Not usually on its own, no. A mother's desire for confidentiality shouldn't usually outweigh a committed father's right to be informed and consulted, although it is a factor to be considered in the proportionality exercise.
But there are exceptions to this notification requirement, particularly if safety is a concern.
Yes. The case of REM, Rights of Natural Father, 2001 FLR 745, is a key example where the court found no breach of Article 8 despite the father not being contacted or notified.
Why was that?
This was because the mother had a credible fear of violence from him, and the court found that protecting her and the children's rights to health and safety justified this exceptional interference with his potential family life rights. Safety trumped notification. More recent cases like MVFH, a local authority, 2011, and REP, a child, 2014, continue to show the delicate balancing act required by courts when assessing Article 8 rights, engaging the right, identifying the interference, and then rigorously assessing whether the interference is necessary and proportionate in all the circumstances, particularly weighing it against the paramount welfare of the child and safety considerations.
So while the law around dispensing with consent certainly engages the human rights of birth families, the prevailing view is that the ACA 2002 framework, when applied correctly according to the principles in REB, REBS, and subsequent cases, is generally considered human rights compliant.
That's the key distinction. It's not the statutory provisions themselves that are necessarily incompatible, but the potential for misapplication. When courts follow the stringent process rigorously assessing all options, considering support for parents, applying the welfare checklist, performing the five-part proportionality test, the conclusion that non-consensual adoption is the only option where nothing else will do is deemed a necessary and proportionate interference with Article 8 rights for the paramount purpose of securing the child's welfare.
So correct application is key to compliance.
The law aims to achieve compatibility by ensuring that the decision to permanently sever family ties is only made when it is truly required for the child's best interests throughout their life.
Okay, we've covered a tremendous amount of detail: the statutory framework, the core principles, the process, the case law, the human rights considerations. Now let's make this practical, especially for those preparing for an exam, by looking at how these concepts apply in real-world scenarios. Our source provides sample examination questions, along with advice on how to tackle them. So let's use those as our test cases.
Good idea. This is where you see the principles move from abstract ideas to informing concrete decisions. Let's take the first scenario, the case of Jason.
Okay, key facts recap. 16-year-old mother Allison has baby Jason. Jason is initially raised by his grandparents, Mr. and Mrs. Smith. Then Allison decides she wants a stranger adoption, and Jason is placed with prospective adopters, Mr. and Mrs. Brown. Allison later changes her mind again and wants Jason back. Lots going on.
Indeed. The first critical legal issue, as our source advice highlights, is the initial placement of Jason with Mr. and Mrs. Brown. If this was done directly by Allison, bypassing an agency or the required notice to the local authority.
Which sounds likely given she just decided.
It was likely an unlawful private placement under Sections 92 and 93 of the ACA 2002. This is a criminal offense for both Allison and potentially the Browns if they received him knowing it was unlawful.
But as we learned, an unlawful placement doesn't necessarily block an adoption order, though it requires a high court dispensation. That re-see line of cases.
Exactly. The illegality of the placement doesn't automatically prevent the Browns from adopting if it's in Jason's welfare, but it's a significant factor the court would scrutinize, and it legally requires that specific high court dispensation. It could potentially color the court's view, although the paramount focus remains Jason's welfare.
The Browns want to adopt Jason. They need to meet the eligibility requirements. There are a couple, presumably over 21, and Jason is under 18 and unmarried. Jason has had his home with them, assuming it wasn't a proper agency placement due to the potential illegality. They'd need to have met the relevant residence requirement, perhaps relying on the longer periods or needing directions. Crucially, Allison is now refusing consent.
Right. So the Browns' path to adoption depends on whether the court will dispense with Allison's consent under Section 52 of the ACA 2002. This decision rests entirely on Jason's welfare being the paramount consideration.
The Re-BS test applies.
Absolutely. The court will apply the principles from Re-B and Re-BS. They will consider Allison's capacity to care for Jason now, the support available to her, and critically, whether adoption by the Browns is truly necessary, applying the nothing else will do test via the 5-part exercise from CMB Blackburn. Allison's history of indecision would certainly be a factor in the welfare assessment regarding her stability. The court would compare the option of him returning to Allison, remaining with the Browns via adoption, or possibly an SGO for the Browns.
Now, Allison wants Jason back. What's her legal route? What does she apply for?
Allison would need to apply for a child arrangements order under Section 8 of the Children Act 1989, seeking an order that Jason lives with her.
And the court's test for that, is it different?
The core test is the same. Jason's welfare is again the paramount consideration, this time under Section 1-2 of the CA 1989. The court would apply the CA 1989 welfare checklist, which is very similar to the adoption one.
But Jason is settled with the Browns now. That must matter.
Yes, a significant factor here is that Jason is settled with the Browns. The court would have to weigh the benefits of returning Jason to his natural mother against the potential harm to his welfare from moving him away from the settled environment he has established with the prospective adopters. While Allison is the natural parent, a significant factor under cases like Ray G 2006 and Ree B 2009.
The natural parent presumption isn't absolute.
No, it's a factor, not a trump card. She doesn't automatically succeed if the move is deemed too detrimental to Jason's welfare.
What about alternative orders for the Browns? Could they get something less final than adoption, especially given the dodgy start?
Yes, the source advice mentions a special guardianship order under Section 14A of the CA 1989 as a potential alternative for the Browns. An SGO would provide them with parental responsibility and legal security as carers without completely severing Jason's legal ties to Allison.
And the court might prefer that.
Given the complication of the possibly unlawful initial placement, the court might view an SGO as a more proportionate and less interventionist way to secure Jason's long-term welfare with the Browns compared to formal adoption, which carries that historical baggage in this scenario and is meant to be a last resort.
And what about Mr. and Mrs. Smith, the grandparents, who initially cared for Jason?
Yeah.
Do they have any options?
If they wish to seek a legal order for Jason to live with them, a CAO, they would likely need leave, permission from the court to make that application, as they don't have parental responsibility and aren't applying as prospective adopters.
Assuming they get leave.
If granted leave, their application would also be assessed under the CA 1989 Paramount Welfare Principle and Welfare Checklist. If the court were choosing between the Smiths and Allison, Allison, as the natural parent, would likely have a stronger claim based on the principle in cases like Regi, provided her current circumstances and history of indecision didn't significantly undermine the welfare assessment for her.
That covers the Jason case nicely, showing how multiple legal routes and welfare considerations are at play. Let's move to the second scenario, the case of Zoe.
Okay, key facts. 20-year-old mother Pippa gives her baby, Zoe, to her godmother, Rebecca. Rebecca wants to adopt Zoe and gave Pippa £5,000. Pippa has now settled and wants Zoe back.
Right. The most immediate and glaring legal issue here is the money transaction, that £5,000.
Absolutely. As our source materials advice rightly highlights, the payment of £5,000 from Rebecca to Pippa immediately raises huge red flags under Section 95 of the ACA 2002. If that money is construed as payment for the child, or for agreeing to the adoption, it is a serious criminal offense.
You cannot buy a child for adoption.
Precisely. Children are not commodities, and any such payment would weigh extremely heavily against Rebecca in any adoption application. It undermines the fundamental principle that adoption is based on the child's welfare and finding a suitable home, not on financial transactions. It poisons the well, basically.
Rebecca wants to adopt Zoe. Pippa is refusing consent and wants her back. What does Rebecca need to do to pursue adoption?
Rebecca would need to apply for an adoption order and, since Pippa doesn't consent, seek to have Pippa's consent dispensed with under Section 52 of the ACA 2002, based on Zoe's welfare being paramount. However, the payment issue would make her application very, very difficult,
Almost impossible.
likely proving to be an insurmountable barrier as it profoundly impacts the court's assessment of her suitability and whether the adoption could be justified in Zoe's welfare.
And Pippa wants Zoe back.
Pippa would apply for a child arrangements order under Section 8 of the CA 1989, seeking an order that Zoe lives with her. Again, Zoe's welfare is the paramount consideration, applying the CA 1989 welfare checklist.
Zoe's settled with Rebecca. Would the court consider it detrimental to move her, even though she's a baby?
Yes, the court would consider the disruption of moving Zoe from a settled home, even as a baby. However, as the source advice suggests is likely, given Zoe's very young age and the strong principle that children are best raised by their natural parents unless their welfare dictates otherwise, the court would likely favor Zoe's return to Pippa, especially as Pippa is now settled.
And the payment makes Rebecca's case weaker.
Massively. Rebecca's position is severely compromised by the illegal payment under Section 95, making an adoption order highly unlikely to be granted, which strengthens the argument for Zoe's return to her birth mother.
These sample questions really pull together the key issues: the importance of the statutory process, the role of consent in dispensing with it, the paramountcy of welfare under both the ACA 2002 and CA 1989, the consideration of alternatives like SGOs, and the significant impact of illegal acts like private placements or payments.
They are excellent illustrations of how you need to identify the core legal issues. Cite the relevant statutory provisions, SS 46, 67, 1, 42, 47, 52, 21, 92, 93, 95, ACA 2002, SS 8, 14A, CA 1989, and key case law. Re-B, Re-BS in particular. Apply the welfare principle and relevant checklist, consider available alternatives, and assess proportionality and human rights implications. That's the method.
Okay, we have covered a significant amount of ground in this deep dive into adoption law under the ACA 2002. Let's take a moment now to quickly recap the key legal principles, concepts, and statutory provisions we've explored, linking back to the learning outcomes that structure this material. This is your mental checklist to see how much you've absorbed.
Good idea. So, we started by defining the fundamental nature of adoption as a legal process created by statute and stating its modern purpose: finding families for children, not children for families.
Right.
We then delved into the profound legal effects of an adoption order, the irrevocable transfer of parental responsibility under S.46, and the creation of new legal parentage, as if born to the adopters, extinguishing previous legal ties under S.67. Remember, irrevocable and as if born to.
We covered the eligibility requirements, identifying who may adopt: couples married, civil partners, enduring relationship, sole applicants, single natural parents excluding the other, relatives referencing SB 50 and 51, and who may be adopted: any unmarried person under the age of 18 and 49, discussing the rationale behind these limits.
We explored the preliminary requirements before a court can make an order, including the crucial residence requirement under S.42, 10 weeks agency, 6 months step-parent, 1 year foster parent, 3 and 5 years relative, and the notice requirements to the agency or local authority under SS.43 and 44, which lead to suitability reports. And we detailed the two fundamental conditions under S.47 that must be met: the consent condition or the placement condition, one or the other.
We spent significant time on the court's powers and the core principles guiding their decision-making when making an adoption order under S.46. The most important is the paramountcy of the child's welfare throughout their life, contrasting it with the previous law's first consideration. Big change.
Crucial change. We also covered the no-delay principle, the specific factors in the welfare checklist: remember wishes, feelings, needs, effective severance, background, relationships, harm, etc., and the no-order principle, which compels consideration of alternatives. Always ask, is this order better than no order or another order?
We dedicated time to the critical issue of consent. Consent to placement The process of dispensing with consent under S.52 when welfare demands it.
And the absolute necessity of understanding the principles from Ray B and Ray BS the last resort, nothing else will do, draconian step, highest level of evidence, and the need for proportionality in considering all realistic alternatives, including support for parents, as further clarified by the 5-part test in CMV Blackburn. You cannot overstate the importance of those cases.
Absolutely essential. We also discuss placement orders and their effects, including conferring PR but not extinguishing birth parent PR until the final AO.
We examined the significant alternative order introduced by the ACA 2002, the Special Guardianship Order, SGO, under SS 14AG of the CA 1989. We described it as a halfway house providing permanence and PR without severing legal ties, noting its preference in interfamily cases and referencing key cases like Re-S and Re-PS.
Less interventionist in adoption.
Generally seen that way, yes. We also revisited step-parent adoptions and the proportionality test for dispensing with consent from the other parent, S512 Re-PA Re-L.
We discussed post-adoption life, including the evolution of views on contact and the specific statutory basis for post-adoption contact orders introduced by the 2014 Act under S.51A of the ACA 2002, including who can apply, adopt your child, others with leave, and the test for leave. We also covered the adopted person's right to know about their origins, including access to birth information, Meta.78, and the Adoption Contact Register, referencing cases like RV Registrar General, XP Smith, and DV Registrar General.
And finally, we described the significant and pervasive impact of the Human Rights Act 1998, particularly Article 8, right to private and family life, throughout adoption law, emphasizing how Re-B and Re-BS have shaped the application of the law to ensure compatibility.
Making sure it's proportionate.
Exactly. And considering specific issues like the notification of unmarried fathers, referencing Re-H and PC and S, but also exceptions like Re-M, the conclusion is that while the law engages human rights significantly, it is deemed compliant when applied correctly according to the established principles of necessity and proportionality for the child's paramount welfare.
The Reflect and Review sections in your source material provide an excellent self-assessment tool based on these core learning outcomes. Can you confidently explain each of these areas, cite the relevant statutes and key cases, and apply the principles? If so, you're building a strong foundation. Use them for revision. #outro. Wow, that truly was a deep dive into the complex and incredibly important area of adoption law under the Adoption and Children Act 2002. We've journeyed through the fundamental principles, the step-by-step process, the critical legal tests around consent, always circling back to the paramount welfare of the child and the need for proportionality and considering alternatives, particularly informed by those landmark Re-B and Re-BS cases.
Yeah, those cases cast a long shadow over everything, really. We've looked at the crucial alternative of special guardianship, explored post-adoption life and the right to know, and seen how human rights principles are woven into the fabric of the law.
It's a field that constantly balances competing, deeply human interests, the drive for a family, the rights of birth parents, and above all, ensuring the safety, stability, and lifelong welfare of children who need permanence, all governed by a precise statutory framework that demands careful and principled application.
It's high-stakes law, impacting lives profoundly.
It really is. We really hope that extracting and elaborating on these key nuggets of knowledge from your source material has clarified the legal landscape for you and provided you with the essential concepts, statutory provisions, and crucial case law you need to navigate this topic confidently, especially as you prepare for your exam. Good luck again with that.
Yes, best of luck to everyone studying this.
Here's a final thought for you to take away and perhaps mull over. Considering the strong legal emphasis on the child's welfare, including being raised within their natural family, as stated in Re-B, how does the legal system continue to grapple with the reality that achieving the necessary permanence for some children requires the irreversible legal severance of those same natural family ties? It's a fundamental tension built into the very structure of adoption law. How do you reconcile those two things?
Keep exploring these complex questions. Understanding the tensions helps illuminate the purpose and application of the law. It's not always black and white.
Absolutely. Until the next deep dive.